It's 8 a.m. Good morning. Uh, wait just another minute or so to get started to allow more of our attendees to join. Thank you for those who are here earlier on time. Thank you. Why don't we go ahead and get started? Thank you for everyone who has come and joined us. We're going to record this and have it available should you wish to revisit it, or if you aren't able to join us for the live version. Today we're doing a mid-market guide to fund formation process. My name is Adam Cohen, and I'll be sort of your moderator for the day. We are offering CLE CP credits. In order to be entitled to claim those credits, you will need to respond to all the polling questions and complete the evaluation form. That'll be emailed to you afterwards. If you have any questions on that, you can email Sydney Sachs. Today's presenters include myself, my partners Amy Bowler and Chris Myers, and our of counsel Ryan Nichols. Next quarter, we're trying to do this on a quarterly basis. Next quarter, we'll be presenting in more detail on particular segments of this. This is, you can think of today's program as sort of your 101 to fund formation, or maybe even pre-101 in some cases. So if you have any questions as we go along, please feel free to put those into the chat or Q&A section of the WebEx, or you can email any of us during the presentation or after, though we probably are not monitoring our emails during the presentation. So the first polling question, I'll let everyone take a second to respond to that. Current prospective involvement in a fund, where are you coming from on this? While you guys are answering that, I will go ahead and start talking about the fund structure. What are the entities when you're forming a fund that you need? So at a minimum, you need the fund. So that might be a private equity fund, it might be a hedge fund, it might be a real estate fund. We're going to talk primarily today about private equity funds, but many of the concepts and agreements and things that we'll talk about apply to hedge funds, real estate funds, etc. Luke, if you'll go ahead and close the poll. The fund often is in a limited partner structure. So that limited partner structure, partnership structure, generally then involves limited partners, that's your investors, and general partners. That's the one party who manages or controls the fund. When we talk about investors, we may refer to them as limited partners. When we talk about the manager, the person who controls or manages, we may refer to them as the general partner. Some funds are in LLCs, in which case there's no general partner per se, and that person would otherwise be either usually the manager or sometimes a member and manager. But in any event, we'll refer to them still as the GP. That general partner is usually the one entitled to the carried interest. They usually will make either directly or through affiliates, they'll make their investment in the fund, the GP side investment. Because of those economics, in part, there's often a management company. And the management company serves the function of being where the actual employees are, where the actual management occurs. That might be the registered investment advisor, which my colleagues will be able to discuss. But the management company will then also serve, if you get to a point where you have multiple funds being sponsored by a single group, the management company will tend to service all of those funds, while each fund may have its own general partner. Because the management company is not a direct investor, typically, and is not a recipient of the carry, that management company will typically be involved through that management contract. Some funds will also have what's called a master feeder structure, in which case you can imagine this with a second fund below the blue box. And in that situation, you have that investors coming into a feeder fund. That feeder fund invests in the master fund, and the master fund does the actual investing, be it in real estate, securities, what have you. The feeder fund serves the function of dealing with issues directly with investors, and allows then potentially for multiple feeder funds. So you might have a feeder fund for taxable, US taxable investors. You might have a feeder fund for tax-exempt investors or offshore non-US investors. Which brings up the point of where are these entities located? So the fund or a master and a feeder, where they are located will depend in large part on what investors you have coming in. It will also depend on what you're investing in. So if you're investing in partnership type portfolio companies and you have non-US investors, you will have one or more of those offshore. And as the slide indicates, there may be blockers involved. So it may be that you have an offshore feeder that is itself a blocker. What is a blocker? A blocker is an entity that is taxed in the United States as a corporation. So it may still be a partnership type entity. It might be a Cayman exempt limited partnership, it might be a Delaware limited partnership, it might be an LLC, but it would be taxed in the US as a corporation. And the idea there is to block any US trade or business, or any, in case of any tax exempt investors, any unrelated business taxable income that would otherwise flow up to those investors and cause problems for those investors. And so it blocks those types of income. Sometimes, instead of a master feeder structure, you might see parallel funds. Parallel funds would be essentially seeing this double or triple. So you would still have the single layer fund potentially, and then a second fund for perhaps the non-US investors, perhaps a third fund for ERISA investors. those parallel funds would then each invest in portion into the portfolio companies. There are also concepts of alternative investment vehicles that you may hear, and those would be generally specific to the particular investment and the investors, and so I won't spend any time on them. But know that in case you hear that concept, you would have this sort of structure generally for your investors, and then a special structure would be done with a tax person like myself to accommodate specific concerns with, say, a Spanish investment. With that, I'd like to turn it over to my partner, Amy Bowler, to talk about if you have a structure like this and you're offering to investors, what's the first set of documents you need?
So I'm going to talk about the private placement memorandum. In the private placement memorandum, or PPM, does a lot of work in this when you're offering securities. When you're offering an investment in the fund to investors, you are offering a security, and you want to disclose to investors what it is that you're offering and the risks of the investment. The PPM does a number of things, though, in addition to just being a compliance document. It allows you to tell your story, and that structure that Adam just described for you can sometimes be complicated. And so this allows you to explain in very plain words, in plain English, what the structure is and how it works, who the principals are, who will be operating the fund, what your investment philosophy is, what your target horizon, your exit strategy. So it allows you to tell your entire story, to explain how you differentiate yourself from other funds and other investments. It also, of course, covers off risk factors. Risk factors are things that that people frequently don't want to talk about, but is very important. You want your investors to come into this investment in a fund understanding the risks attendant to being a purchaser of an interest in the fund, and the investment strategy that you have. Risk factors I like to think of as a relatively inexpensive form of insurance, because if you have thoroughly advised your investors about the risks that they face, it makes it more difficult for them to bring certain types of claims against you should things not work out as everyone had hoped. The risk factors are protective to the extent that they are accurate and that they are specific. So a lot of time is spent trying to make sure that the risk factors describe the risks that are truly tailored to the investment, to the fund, the interests that you're offering. So to the extent that they do, tell the truth, the whole truth, nothing but the truth, and the risks relating to it, this offers protection to the fund sponsor when offering interest in the fund. Generally, the fund also provides a summary of the terms of the fund agreement. So you have a description of what is the actual security that these investors are buying. And so you lay out the material terms of the fund operating agreement. You also generally have a tax disclosure. So again, investors understand the consequences of their investment. Some funds, the tax disclosure is fairly light. Other funds that have a tax-driven investment strategy, of course, would have much more specific tax disclosure. So in a nutshell, it is talking about what your plans are, who is going to be operating this fund, what are the fund's goals and strategies, what are interests of management. Frequently, there are a significant amount of related party transactions and potential conflicts, and so the PPM will describe those. What are the risks and what are the tax consequences of the investment? And this helps investors make their investment decision, and it offers protection to those who are offering these securities in the event that things don't turn out quite as planned. I think I will, I know that was a very quick summary of the PPM, but I think that we covered the key parts. And so I'm going to turn it over to Ryan now to talk more specifically about the fund agreement itself.
Thanks, Amy. Good morning, everyone. Thank you for joining us this morning. As Amy said, I'm going to talk a bit about the fund agreement itself from the perspective of the general partner who's preparing it in connection with commencing an offering. And as Adam alluded to earlier, this really is, it's a 100,000-foot view. So I'm going to cover some material terms of the fund agreement in the next 10 or 15 minutes. And I'll touch on the meaning and some examples. You know, each one of these items is really appropriate for its own 50-minute presentation in some respects. So for example, last year we did an entire 50 minutes on carried interest. So, you know, bear with me. Hopefully you're left wanting and you'll join us again in a quarter. So the first part of the fund term that I want to talk about is the duration. As Adam said, we're really talking about closed-end funds here, private equity funds, venture capital, emerging growth, et cetera, with limited terms compared to a hedge fund, which is a open-ended fund with a perpetual existence and a withdrawal right. So we're not going to talk about that today. We just don't have the time to do it. So let's focus on this from the perspective of a middle market private equity fund. Typically, your fixed term for one of these funds is going to be somewhere in excess of 5 years and usually up to 10 right now. That's going to depend on the strategy, and you know, if you're a fund that's going to be investing in more liquid investments or investments that are faster to maturity, you're going to be on the lower end of that because your harvesting period may be shorter. Now, typically, in addition to your main term, your primary term, you're going to have some extension options. Right now in this market, it's usually a couple of 1-year extensions, and then depending on the leverage of the general partner, the history of the fund, it's likely that the first extension is going to be in the general partner discretion, whereas the other ones may require limited partner advisory committee or LPAC consent or some other form of investor consent. As I just mentioned, that in itself really depends on the history and prior success of the fund and its managers. And each one of these items that I talk about is really going to be influenced by that. How many funds have there been? How successful have they been? Are they going to be oversubscribed or undersubscribed, et cetera? So I'm trying to keep this very, very much down the middle, but just know that there can be significant variation in these terms depending on where the leverage points are. The fund term is subject to early termination in a number of different situations, including, you know, general partner bankruptcy. But what's of the most important to the general partner as well as the investors is there going to be an early termination either for cause or without cause. Funds that are a little bit younger are more likely to offer, or whose managers are a little bit newer to the space, are more likely to have to offer a not for cause termination. Somewhere in the area of 85% of the limited partners would be required to trigger this. And then there's a for cause concept of early termination of the fund, which results from the bad acts of the general partner, the bad acts of the general partner's principals and managing members, and maybe the investment manager. Now, when I say bad acts, I'm talking about a possibly large list. You know, some funds may push for something that's simply willful misconduct, whereas others may push for anything from gross negligence, willful misconduct, fraud, breach of the agreement, breach of fiduciary duties, et cetera. So those are some considerations you'll have to make when preparing this agreement. Is what rights do the LPs have to terminate the fund, at which point the GP would be required to liquidate. Now, briefly, the fund term is broken up into a couple of stages of its life cycle. So once you complete your marketing and fundraising and you actually close on the fund, which is a topic for another day, the first period is the investment period, also known as the commitment period. Now, this is typically going to comprise the first 3 to 5 or 6 years of the fund's life. And it's during this time that the general partner is allowed to make drawdowns for new investments. So we're assuming, again, this is a committed capital fund where drawdowns are made incrementally in order to make investments. So during this investment or commitment period, the GP can make drawdowns for new investments. The next period, once the investment period ends, is referred to by a number of different ways, but it's often referred to as the harvesting period or the follow-on period. And it's during these last 3 to 7 years that the fund is making follow-on investments in existing investments, which are either to sort of enhance the investment or maintain their position. They may be developing the investments additionally, depending on their level of control. And then they'll start to harvest or market them for sale and then ultimately liquidate the fund when they get to dissolution. During the harvesting or follow-on period, no drawdowns, so a drawdown is a capital call, no drawdowns are permitted other than generally to pay expenses of the fund, which are the management fee, to make those follow-on investments in already existing investments, to satisfy certain other expenses that are indemnification obligations from prior portfolio sales, et cetera. So I'm going to jump out of the term and the life cycle now and talk a little bit about some of the key economic provisions. As I said, we're assuming a private equity closed-end fund. We're really looking at a European style waterfall here, which is aggregate among all. So you're making distributions, and the carry and preferred return are going to, which I'll discuss in a minute, are calculated based on all of the committed capital and all of the investments together, and not on an investment by investment basis. So the first key economic term is going to be the fee. Now, the management fee is, there's typically going to be a management fee, and it's going to be charged regularly, usually quarterly. And in addition to paying salaries and having a return just for its investors or its managing members, the management fee is used to pay what are called back office expenses and other expenses of the general partner that are not paid by the fund. So the fund typically pays all expenses incurred except for a handful, which are the sole responsibility of the manager in connection with its operations. I'm sure you have all heard at some point the phrase 2 and 20. It is a very common way of saying we have a 2% management fee and we have a 20% carry. And so the management fee is what that 2 refers to. Now, the management fee doesn't always have to be set at 2, but it's commonly somewhere in that area. You may see with larger funds, they can take advantage of some economies of scale and lower the fee because at some point the management office doesn't need that much to operate. So you may see a higher fee with newer funds, smaller funds, and then with large funds, a lower fee. Now, again, very generally, the management fee is kind of broken up among the 2 periods as well. So on one side, you have the investment period, and typically the fee is calculated based off of capital committed. And then after you get out of the investment period and you're in the harvesting or follow-on period, it's generally going to, you may see a step down, or it could be and/or, you're going to see the base on which the fee is calculated switch over to the amount of capital invested. So that excludes anything undrawn, and it excludes any realized investments. Another economic term is the preferred return or the hurdle. This is a minimum return that has to be paid to the limited partners above its capital commitment before the GP can take any carry or share in the profits, which I'll talk about in a second. This can be anywhere between probably 6 and 10% right now, but usually right in the middle, around 8 is what we're seeing lately. The carry, that's also known as a profits interest. It's a non-capital interest that goes to the general partner. And really what it is, it's a contractual right to share in the profits. Typically, again, very generally, the starting point is 20% of profits above the capital returned and the preferred return. Now that's, as I said, that's the 20 in 2 and 20. Depending on the leverage, that may increase or decrease. In addition, you may also consider having a step up in your carry, 30, 35%, et cetera, once you hit a certain distribution threshold. Say, for example, 3x return on capital, all of a sudden the GP gets to take 30, 35%. Other economic, there may be a catch up. We don't need to get into that too much, but the idea is the GP would be able to catch up and share in that initial portion of the profits that previously went to the limited partners, that preferred return. The GP may have the right to waive a portion of its management fee. The GP may have the right to waive certain carried interest distributions and allocations. The idea here is you're going to defer to the future. In the future, you would receive the waived amount as part of future distributions or allocations. This provides an opportunity for the GP to take a tax advantage position. There may be risks to the GP if the distributions are not sufficient later on. In more economic terms, the GP clawback, if the GP receives more than it should have based on its return, it'll have to give some money back. That clawback may need to be secured either through a guarantee with the individual indirect recipients, sort of the GP members. That's probably one of the most common requests that we see, is that direct privity and that guarantee by those individuals. And the last major economic term that you'll want to consider as a GP is what are you going to make the limited partners return? What is subject to recall? So what portions of their distributions do you want to be able to claw back? Some distributions, for example, are subject to return for indemnification obligations, whether it's at the fund level or at a portfolio level in connection with the sale. Others are subject to return for making future investments. And those are likely going to be capped at 25 to 35% of your distributions, or capped at your undrawn commitments. So that's a really fast sprint through economic terms. The next thing that you're going to see in these fund agreements are conflicts of interest provisions. Typically, the fund agreement will restrict the manager, the general partner, and its related parties from engaging in any self-dealing or conflicts transactions. Certain conflicts transactions are going to be, and you're going to have to decide what these are as the general partner, they're going to be carved out in the fund agreement and in the PPM, as Amy talked about before. And those are things which the LPs will see, you'll be permitted, those are actions you'll be permitted to take. And then you'll also want to come up with another avenue for addressing conflicts of interest in related party transactions, such as LPAC consent, investor consent in the absence of an LPAC. And oftentimes LPAC consent will be sufficient to free the manager from any liability in taking those conflicts of interest transactions. So the conflicts of interest section is going to be very important in the fund agreement. Another component of the conflicts of interest section that you should think about is your successor subsequent fund limitation. Now, the reason you include this is the limited partners don't want you to go and start a new fund in the same space with the same strategy before their commitments are used up. And the reason you may want to do this is, well, perhaps 3 years down the line, 4 years down the line, the market is demanding higher management fees or demanding a higher carry. So this is a protection for the LP that you're going to have to consider. And typically you're going to see this in the range of 70 to 80% fully committed, reserved, expensed, or invested. It may also be at the end of the investment period, you're free to commence a new fund. Another component of the fund agreement, and I'm going to keep powering through so we have time for other stuff, is there's investment limitations. So investment limitations may be made for a certain percentage limit on investments. You can only invest a certain amount in a single company. You can only invest a certain amount in public equities. Often a prohibition on investment in real estate or oil and gas assets, a limit on non-US companies or companies outside of your geographic footprint. So those are a number of investment limitations that you're going to want to think about that your investors are going to raise. Another material component is key person events. Now you're going to need to select key persons that are integral to operating the company, and they're going to undertake to devote a predetermined amount of time to the fund, which is typically going to be something akin to substantially all their business time. And then maybe after the investment period, it's whatever's reasonably necessary. The failure for them to take these actions, depending on the number of key persons, will result in what's called a key person event. And that usually gives rise to an automatic suspension of the investment period or a right to suspend the LPs to suspend the investment period. So you can see there's bad acts. There's also failure to give proper time and attention. All are things that give the limited partners recourse and comfort that the GP is going to do what they say they're going to need to do. A couple others, transfer restrictions. Generally, nobody's going to be able to transfer without the GP's consent. But the GP, you need to think about what limitations are imposed on transfers of your interests. For example, what percentage of interests is the GP allowed to dispose in the company to a third party before consent is required by the LPAC or the investors? Perhaps it's a majority. You want to make sure the GP still has stake. But oftentimes, LPs are going to want to look at the next tier, the managing members of the GP. You want to make sure that they're not disposing of their assets. And if you have a fund that's managed by a registered investment advisor, there's some inherent protections in the Advisors Act. But if this is an exempt advisor, you're going to want those contractual protections at the least. I'm going to kind of gloss over, in the interest of time, I'm going to gloss over investment or legal restrictions, regulatory aspects, but you need to be aware of the limits on investments by bank holding companies. You may need to include language for that. Foundations or tax exempts, they're going to have interests in limiting unrelated business taxable income, UBTI. There may be ERISA issues. You want to make sure you're not becoming a fiduciary by having too many assets to the point where they're deemed to be plan assets. And there's other ones as well that I will just gloss over. One more key provision that you may see is an excuse right. An excuse provision allows the GP to excuse a limited partner from its obligation to fund its capital commitment or to provide a refund to the extent a excuse subsequently comes into play. This may be due to regulatory restrictions or internal policies. For example, maybe an investor's unwilling to invest in munitions or gambling or things like that. So you'll need to decide how that deficit's made up if you want to take those steps to be able to excuse an investor. And lastly, I'll say other material terms of exculpation and indemnification. I'll touch on that in a little bit in the investor context. There's going to be a power of attorney. You're going to want to consider the ability you have to act on behalf of the LPs. What's it going to take to amend the agreement, and are there any redemption rates? So thank you. I know we blew through a lot. I'm going to turn it over to Chris Myers now, who's a shareholder in our Vegas office, who's going to chat about side letters.
Thank you very much, Ryan, and thank you to everybody for joining our presentation today. And so, as we've walked through here in connection with a general partner looking to form a fund, we've covered the PPM and the LPA, and now you as a GP think you're ready to go, and an investor comes to you and says, "Those are great terms, but here's the special deal that I want." And for a lot of GPs, that can be an overwhelming moment. You said, "Hey, I just spent all this money on a PPM. I just spent all this money on an LPA. I had everything the way I wanted it to work. And now the investors with the cash all want a special deal." Well, enter the side letter. Lucky for general partners, the side letter is a way to have different contractual arrangements with specific investors. The downside to side letters is that they are expensive. It is essentially a mini economic or reporting or transfer right contractual arrangement with specific investors. And for a lot of general partners that are on fund or people that are thinking of forming fund one, the big issue is cost. And, so looking at, do I need to have side letters? The usual measurement stick is looking at your limited partner base or prospective limited partner base. Do you anticipate investors wanting special arrangements? Usually they're around things like economic rights, reporting rights, transfer rights. When you start dealing with, governmental entities, or insurance companies or private foundations that are going to write very, very large checks, they're going to have a whole list of special arrangements that they need relative to their entity type. And so for the standard side letter, for a general partner, one of the real tools of it is it takes those individual deals out of a limited partnership agreement wherein all limited partners or investors would benefit from that provision, and tucks it into a document where it benefits that one investor, or if the side letter has what's called a most favored nations provision, all similarly situated investors. Now, for Fund One, one of the most powerful side letter provisions that a general partner can give to an investor is what we refer to as an anchor investor provision. And an anchor investor provision is sort of, hey, I gotta have somebody be first. And for folks that have not formed a fund before, finding that first investor is often the hardest one, right? Because you get a lot of folks that say, well, I'm in, but I don't want to be the only one. And I want you to have some minimum investment amount before you close on your fund. And so an anchor investor provision can be a way where you get special economic rights, discounted management fees, discounted carried interest, perhaps some type of preferred co-investment rights, some preferred reporting, whatever it is, to incentivize that investor to be, or that group of investors to be first. And what you would do to make sure that other folks, later stage investors that weren't kind of the first in, betting on you, the GP, partnering with you, a carve out in your most favored nation provision, which is a provision that says, if you invest at or above this same amount, you get the same benefit other than these carve out items. And oftentimes the carve outs are related to, hey, if you're not a governmental agency, you don't get provisions that benefit governmental agencies. Or if you're, if you're not tax exempt, you don't get provisions that benefit tax exempt investors, right? The carve out is essentially, if you're not this type of investor, you don't get the benefit of these provisions because they're just not applicable. Other type of carve outs relate to, if you're not an early stage investor, if you haven't invested over this threshold amount, these beneficial provisions just aren't going to apply to you because it's not fair. The other real benefit of a side letter for a general partner may be you're offering on a continuous basis over some, in a private equity or venture fund, call it 6 to 18 months. And you're offering over this period, you're having multiple closings as additional investors come along. And there may be a handful of things where people come along and say, hey, I think this provision isn't clear to me. And that's the benefit of the English language. It can oftentimes be open for interpretation, particularly more complex provisions. A side letter will allow you to individually, with that limited partner, clarify your interpretation on unclear provisions. It'll allow you to add certain provisions where an investor says, I wish this was in the LPA, but it's not. And instead of you, the GP, having to go back to all of your limited partners, go through an amendment process, update the LPA at each of these individual closings, the side letter can be a way to deal with certain things that you wish were in the LPA, certain things that you wish were more clear in the LPA, and allow you to have to go avoid the process of amending the limited partnership agreement, which can take time. As Ryan indicated, these funds are very long-term investments. And so there are people that will make an investment and they're saying, hey, I made my money, I'll fund capital calls as they come out, but I don't really expect it back for 10 years. So I'm not going to be monitoring my email account on a continuous basis. So getting amendments to LPAs can be difficult. particularly when you're in the offering stage and you want to just get closed. So side letters can be very beneficial. As I indicated earlier, however, they are expensive. And so if you're thinking of doing fund one and you're, and you're going to be an exempt reporting advisor land and you're, raising less than $150 million for a fund, the SEC is allowing you to be an exempt reporting advisor if you only advise private funds. And a part of that is to allow you to kind of ramp up your AUM so you have money to afford to comply with all of the compliance obligations that a registered investment advisor has to comply with. The side letter process should be looked at as fairly similar. If you're only raising a little bit of money or relatively not a lot of money, going through a side letter process, which may have to be bookended by a most favored nation process where you deliver copies of all your side letters to every investor, or you can extract out the provisions that you gave to certain investors and you deliver it to all other investors that have a most favored nation right. Allow them to review it and elect the provisions that they think that they wish they had for investors that invested the same or less than they did. So that process can be expensive. The process of negotiating side letters with individual investors and their counsel can be expensive. So although they're a great fix, they're a great tool to incentivize certain investors. They may be required but by certain types of more sophisticated investors. While great, they are expensive. And so when we deal with fund one for a general partner looking to do a social impact fund or a series seed fund, and they're looking to raise a de minimis amount of money, we might say, go do an executive summary with investors, test interest, get a PPM, and let's get everybody's unique ask into the actual LPA so we're not doubling or tripling the cost of forming the fund. So great tool, expensive, but can certainly help paper over unique issues for your investors and make them feel vested and eager to be in. With that, I will pass it back to Amy to talk about the final part of the offering, which is the subscription agreement / receipt / sign that you won and you got the investor in.
And I'm going to run through the subscription document quickly since we're falling behind our ambitious schedule a little bit. The subscription document is the contract pursuant to which the investor makes an offer to acquire interest in the fund. And the GP or manager gets to determine whether they accept it in whole or in part. So the GP can look at all of the subscriptions and size the transaction, and there can be some strategy to determining what size of investment you take from various investors. The subscription agreement also allows you to establish that you have satisfied the securities exemptions and conducted appropriate due diligence on your investors. As we stated before, when you are offering these interest in funds, you are offering a security, and that offering of a security needs to be exempt from federal and state securities registration requirements. So the subscription agreement, which is usually a very lengthy document with many different questions and representations from the investors, all of that goes to demonstrating that you have satisfied the various requirements for utilizing and relying upon certain exemptions from registration. You will also gather important tax information, and you will gather information from investors that helps demonstrate you've conducted appropriate due diligence to ensure that your investors are not engaged in money laundering or other activities that they shouldn't be engaged in terms of the money that they're investing in the fund. So it's an important document. It's a document that is lengthy, and people frequently wish it were shorter, but it serves a very important purpose of establishing your compliance with law and the fund's compliance with all of the applicable securities laws. So I will then send it over to, I think I'm sending this over to Adam now.
Thank you.
Talk about.
And before we move from focused on what is the GP focused on to what the investors focused on, we have our second polling question. So if everyone could take a minute to discuss, to look at that and response, we'll then move on. So from a limited partner perspective, from an investor perspective, what are you focused on when you are looking at one of these funds that this GP has put all this effort into putting together, bringing to you? We're lawyers, so we're not going to be talking about actual investment considerations. So, that is probably the most important, right? Does this fit your portfolio? Do you think the returns are good? Do you think the market segment that they're focused on is going to be performing better than other investments? What are the alpha, beta, et cetera? All those considerations are super important. But when you come and talk to your lawyer, we generally don't have much to say about those things. So from a legal perspective, what you have to focus on is thinking about what is important to you. Each investor has their own bugaboos. So some may be based on classification of investor. Maybe you're tax exempt and you care about UBTI. Maybe you're a U.S. taxable investor and you're looking for something more tax efficient. It may be that you want to focus on, you have, as Brian pointed out earlier, maybe there are certain industries that you do not want to invest in at all. You don't want to touch. So those types of things need to be considered before you really release your lawyer to go looking at the documentation. The other aspect of going into a negotiation with the general partner is reflecting on what your negotiation strength is. Chris mentioned, this concept of an anchor investor. If you're an anchor investor, you have a fair amount of ability to influence the documentation, whether it's through the side letter or getting the LPA changed before you actually sign up. If you're a very large investor, if you're going to be, 20, 30% of a fund, you're going to have a lot of ability to get terms that you think are important to include. If you're only 1% of a fund, if you're investing, $100,000 into a $30 million fund, you may have to look at it as a take it or leave it type of investment. So you need to be thinking about this concept of when in the investment period, the fundraising period you're investing. So for example, if you're investing and it's the third closing, and there's been investors who have accepted the documents twice before, it's going to be a lot harder to get changes made than if you're in the first closing. So you have to approach the documentation cognizant of what you care about and how likely you are to get a change. So now I'd like Ryan to talk to us about the approach to take in reviewing the documents.
Thanks, Adam. And I will try to stay brief. We're going to eat into some Q&A time. And then after I go, we'll put up the third polling question in case anyone needs to drop. So as Adam said, there's a number of considerations that are specific to you as an investor. And then there's a number which we see as sort of broad-based, generally applicable considerations. And my apologies to those GPs and sponsors. We're going to give a little bit of info over to the investors now. First, I would say pay attention to the commitment size that you have. Obviously, as Adam and Chris said, if you're a small commitment, you're going to be along for the ride. But you want to be aware of being too large of a commitment as well, and make sure that's at the front of your mind. If you're a significant commitment, you may have exposure to individual investments that you wouldn't otherwise want. You may be overexposed, for example, whether it's by strategy, region, the specific portfolio company, et cetera. There's also, think about whether there's minimum commitments. You know, if the fund is too small, are you going to be bearing more costs and expenses of the fund than you otherwise would? And is that eating into your returns? So, you know, to solve for these concerns, at the very least, ask what's the minimum, what's the maximum, what's your expected closing size? Another tip is look for what we call gotchas or potential overreach in the document. You know, these documents are 60 to 160 pages long, and usually somewhere right in the middle. And whether it's an intentional gotcha by the GP, sort of including one sentence that says, if you do this, we have no liability related to X, Y, and Z, or if it's a nit or a substantive error, a lot's hidden in the minutia of the document. So that's why it's good to have somebody really dive down into the nitty gritty, for lack of a better term. Look as well for terms that are kind of atypical. As I said before, every fund is different in size, strategy, the respective leverage of the parties, the terms. The counsel, they have a significant weight when it comes to what does the base document say. But at the end of the day, everybody's kind of within a band typically, and what is standard, what is market. So look for atypical terms. A lot of times if they're being proposed by the GP, they're going to be GP friendly. Perhaps enhanced economics, reducing their risk, additional protections from the point of exculpation, indemnification, et cetera. And that leads me into take a look at what is the general partners, the managers, their related parties' standard of conduct. So typically, they're going to be held harmless if they act in good faith, or they'll be indemnified if they act in good faith, and so long as their action didn't constitute, again, one of those kind of bad acts, gross negligence, willful misconduct, fraud, breach of the agreement, breach of fiduciary duties, et cetera, whatever's negotiated. So make sure that you understand their standard of conduct, and also it can be adjusted throughout the document. So for example, a partnership representative who's a person appointed to deal with the partnership tax matters and bind the fund, well, they may have a different level, a different standard of care. So is that acceptable to you? Take a look. Are they fully exculpated for relying on a third party? Are there any sort of parameters around that? Does it have to be in good faith? Does it have to be reasonable? Do they have to provide all information? Do they have to monitor those people? Think about those from the perspective of an investor. And another one is broadly, we talked about it in the context of the GP, so I'm not going to belabor it, but what is your right if things go poorly? In a hedge fund, you can just withdraw subject to the gates limitations usually, but do you have a right to remove the GP for or without cause? And what is that standard? Does it require a court decision? If they act badly, will the GP have to take a haircut? Is there a termination right for the investment period? Is it just a suspension? Can you terminate the fund? And then I think the last big one that I'm going to hit on is what is your role on the advisory committee, the LPAC? And that's something which is going to be part of the side letter. It's going to really depend on your size, your leverage and status as an investor. And what the LPAC typically does is, well, they oversee certain aspects of the fund, the management of the fund, but they don't actually have any management or binding rights. They can maybe review valuations, consent to investment limitation increases, approve conflicts transactions at the request of the GP. So if you get on that, if you want to have a seat, make sure you're looking for, are your members insured for whatever actions they take? What's the standard of conduct? Typically, it's going to be somewhere about, they just have to act in good faith. And is there, what's the indemnification for the appointing limited partner? Real fast, 30 seconds. When you're negotiating the fund documents, you know, we talked about how there's a number of legal documents. The primary legal review is going to focus on the LPA or limited liability company agreement, with whatever the form is. But also, council can be used to look at differences between the PPM and the LPA. The PPM is typically business facing, but oftentimes council won't really know how to review. They know how, but they don't know what you're looking for in conflicts and risk language. So it's really important as an investor that you're reviewing the conflicts of interest language, the business language, and relying on the lawyers for the legal component, like Adam was saying. And typically you're not going to be submitting markups. Sometimes the fund may request it, but prepare to send long or short, whatever it is, issues lists, because the fund wants to control the document and they want to look at the whole universe of comments while they negotiate. So anyways, thank you. I think Chris has one more comment on side letters, but Adam, do you mind doing the poll before we bump up against 9 o'clock?
Sure. Go ahead, Chris.
Oh yeah, and so now that we're looking at fund documents from the perspective of the investor, side letters take on a whole new meaning, and it goes from a may help fix some things, but expensive, to you want it, and if your check is big enough, you should absolutely get one. And the primary term that an investor should have in a side letter, if you're, just to be safe, is what we call most favored nations provision. And again, what it does is it entitles an investor to, subject to the NFN carve-outs, to receive the rights given to investors that invest the same or less than a particular investor. Now, side letter provisions may go from, I really want this, to you may, statutorily be required to have it, depending on the nature of the investor. So governmental entities, nonprofits are often going to have all kinds of unique restrictions. Nonprofits may have issues around UBTI. Adam, unrelated business taxable income. Adam mentioned feeder structures or blocker structures. If general partners won't give on that, another way is to have side letter provisions that say, hey, if you're going to generate UBTI, make it through a blocker entity. So there's also, hey, if I'm an anchor investor, give me a discount on fees. There's also, if you're a governmental entity, there's unique things around Freedom of Information Act type laws. Also indemnification. Spoiler alert: governmental state agencies won't indemnify you if you're a GP. So there's a whole litany of things that an investor, beyond just economic rights, may say, I must have these things, right? Reporting, special rights around indemnification, special treatment around generation of UBTI, transfer rights. If somebody says, hey, the tax exempt investor says there's just too much UBTI generated, I need to transfer this to a different entity. Governmental agency says, listen, there's just too many prohibited investments, I can't invest in this thing anymore. Or I'm an ERISA investor and I just need out. So side letters are a powerful tool from an economic perspective, but they may be an absolute necessity depending on the nature of an individual investor. Side letters are, if you come in late to the game, the number one response you will get from a general partner to your comments are, we already had our closing, the limited partnership agreement is what it is. But again, that's what side letters are for. And so side letters can really be a powerful tool to reopen negotiation with the general partner on fund terms. It can be a powerful tool to defend your investment entity, your governmental agency. And if you invest enough, it will benefit an investor to have what we refer to as a template side letter and hardwire in all of your unique concerns. Have that side letter approved by your investment committee and say, yes, that's our prohibited investment list. That's our indemnification requirements. And then run that side letter past your internal compliance team, your state attorney general's office, and get it signed off. And then have a process where you're updating that side letter at least annually to comply with any statutory or internal changes that your entity may have undergone. So that's pretty much it on side letters. Like Ryan said, a lot of these topics could be 50 minutes or more in their individual, but I'll pass it back to Adam to wrap up.
Great. Thank you so much. I appreciate my fellow presenters for their time, and hope everyone was able to get a lot of great information this morning. I appreciate also the input that you had on our last polling, and we will definitely take that into account for our next session, which we'll be sending out emails for. If you have any questions that you didn't get a chance to put into the Q&A or chat, feel free to email any of us, and we're happy to respond to those. Thank you for your time, and we hope you have a wonderful day.